Next matter to come before the court this morning is the State of Ohio versus Jeremy Diestler. As you know, each party will have 15 minutes in which to present the case. If you're the appellant, you may have up to 5 minutes for rebuttal. You are aware we need to be in front of the front podium here because I'm keeping track of the clock and we'll keep you apprised of passage of time if you let me know how much time you want for rebuttal.
I would ask for that 5 minutes.
Okay, and we have ready to brief, so we're ready to proceed when you are.
May it please the court, opposing counsel Donald Gallick on behalf of defendant appellant Jeremy Diestler. There's 5 assignments of error presented to the court today, and I'd like the court would allow sort of go out of order on these. The 2 smaller issues, assignment of error 4 and 5, I think are illustrative to the first 3 assignments of error. Assignment of error 4, there's a merger issue. The state points out that counsel didn't get into it. Defense counsel disregarded that issue. Assignment of error 5, there's no compliance with Criminal Rule 32A. The record is very clear. The trial court never personally addresses Mr. Diestler, as the Ohio Supreme Court says you should in State versus Green or State versus Campbell. Again, the state says, well, you know, defense counsel said, I'll speak for Mr. Diestler. Don't worry about him. Don't worry about any of that. I'll just take care of everything. And you know, law wasn't complied with in assignment of error 4 or assignment of error 5, but you could blame defense counsel. And I would say this goes right back into the first 3 assignments of error, that you could blame defense counsel for quite a bit, because it's essentially as Mr. Diestler was unrepresented in this case. And we knew there was an issue of conflict. The trial court had a hearing on it. The prosecution raised the issue of conflict of interest, that it certainly didn't look good for your defense attorney to have previously represented the murder victim. You know, the trial court, I mean, tried to do some diligence here, but eventually came up with this remedy of, well, we'll have the decedent's probate lawyer sign a waiver, and there we go. So the probate lawyer signed a waiver, and Mr. Diestler knows that I represented the murder victim previously, so problem solved. And this court could adopt that view, and some courts have, but like throughout all of the assignments of error, we have some conflict in districts. I mean, the 6th district seems to suggest in the State versus Byrd case that we get into a structural error problem here. And the conflict in State versus Byrd was a lot more de minimis than we had in the case before the court today. In Byrd, you had a client who represented multiple defendants. None of them, I don't think, killed each other or anything like that, but there was some sort of ex parte communication with this defendant or that defendant, and the 6th district said, look, this is just structural error. We're getting into, you know, deprivation of 6th Amendment rights here. Let's just start anew. I don't know if this court wants to adopt that view of the 6th district or go a different way, but when you have a case where, murder case, a high-profile murder case, your defense attorney represented the murder victim, is that something that you can actually waive? Now you say, well, the trial court did a hearing, the trial court looked into it, the trial court called the probate lawyer, but it looks like they solved the problem. The reason we have structural error analysis on this is you can never really know if you solved the error, the issue or not. If the decedent had previously told Diestler's current trial lawyer, said, you know, they got me on cocaine, but I used to sell heroin with this guy, Jeremy Diestler, and I threatened to kill him, or something. Oh, that's useful in this defense here. Defense counsel couldn't bring that up. There would be an attorney-client privilege issue. Now, in the state's brief says, well, look, his former client is dead, so what conflict is there? Well, as this court knows, attorney-client privilege survives death. I think there's quite a bit of law on that. And you get into the situation where we don't know what conversations may or may not have had with the decedent and Diestler's trial attorney. It just turns into a mess where it's not just we don't know, it's unknowable. You couldn't even subpoena, if we wanted to have a post-conviction hearing or habeas hearing, put Jack Bradley on the stand and say, look, tell us everything that your deceased client told you. You can't do that. Well, tell us everything Diestler said when you had the conversation about waiving conflict. Well, you can't do that either. You just get into this entire paradox, which is why I think the 6th district didn't like it. And I cited some federal case law as well that got into 6th Amendment issues of what constitutes deprivation of counsel. But the trial court spotted the issue, the prosecution spotted the issue, the remedy of going to the probate lawyer and saying, you sign it and Mr. Diestler sign it, problem solved. That's an inadequate remedy in this situation. I think this is structural error, and I ask the court to adopt the Sixth Circuit, or the Sixth District's holding in State versus Byrd. The other two assignments of error involve the issue of the jury verdict. Now, you know, the trial judge says, I've never seen in my 10 years on the bench where the jury fills out the wrong verdict form. Well, you know, I've seen it, I'm sure this court has seen it in other cases, that what you do is, if you have a lesser included offense, you put that on the same verdict form as the greater offense. That's not what's done here. They're given a murder verdict form, they're given an involuntary manslaughter form, they fill out the not guilty on the involuntary manslaughter, the trial judge sees it, oh, yikes, we don't want that. They made the wrong, they gave us the wrong verdict. Well, you could say it's obviously a jury error, but is that within the province of the trial judge? And once again, all these assignments of error sort of interrelate, flow into one another. You would think Diestler's trial counsel would object if a trial judge said, hey, we're going to talk to him about this not guilty verdict. I'm going to talk to the jury about maybe changing this verdict. You think a reasonable lawyer would object to that? Yeah, but Mr. Diestler's lawyer doesn't seem to have much concern, doesn't provide much representation, which is apparent throughout the entire trial. Doesn't comply with discovery, gets admonished for that, doesn't really file any motions. What is his defense? We don't know. Why are we having this trial? We don't know. Are you going to object to them trying to alter this not guilty verdict? Nah, I'm not going to say anything about it. At what point do we have a Sixth Amendment deprivation here? Now, I noticed in the state's brief, they said, well, look, it kind of looks like from the transcript, all this conversation happened in open court. So Diestler's trial attorney was present, everyone was present. There was no ex parte communication with the jury or you know, not having a lawyer at a critical stage of the litigation. The problem with that is, and I make some citations in the transcript, to the transcript here, at some points the trial judge is speaking in the past tense of what he told the jury. Now, if everything happened in open court and everybody was present, why is the trial judge telling them in the past tense what happened? That suggests that something happened outside the presence of the lawyers, and it really didn't happen in open court. At a minimum, you would think that Diestler's trial attorney would say, hey, Your Honor, I don't think we should alter this not guilty verdict, or I think we should voir dire the jury, poll the jury, something like that. But no, you look through the transcript, it appears something happened outside off the record and outside the presence of trial counsel.
Counsel, can I interrupt you for a second?
Please.
I'm wondering, when I was reading your brief, your first assignment of error, I'll go back to that for a minute, but like you said, they all kind of go
Yes.
together in some respects. That you argued that the victim's prior counsel was ineffective because he represented, the defendant's prior counsel was trial counsel was ineffective because he represented the victim previously.
Yes.
Are you making an independent argument that he was ineffective in addition to that, or just on the basis of that? Because you're arguing really a structural type error, because like you said, it's very hard to see an actual conflict, but without, you know, having some kind of mini hearing or mini trial or whatever, and getting into attorney-client relationship. So I'm wondering, are you also arguing that he was ineffective, period?
You're right, I think it's a great question, and obviously structural error, you don't need to show prejudice, it's assumed. But if you look through all the other four assignments of error, I keep saying there was no objection, it's plain error. Counsel didn't say anything, plain error. Counsel stood mute, plain error. And so you look at all of this, you look at all five of these in parliamentaria, you say there was defense counsel didn't do very much on this case. I mean, even in allocution saying, Your Honor, you know, I'm going to speak for Mr. Diestler. Well, this is an experienced trial attorney. You can't really, certainly you can recommend your client, I don't think you should make a statement, but you know that he has a right to. The merger issue, defense counsel doesn't say anything. The judge trying to alter and does change the not guilty manslaughter verdict to guilty. What did defense counsel say? Well, there's nothing on the record. What was defense counsel doing? I have no idea. It's like you would do something when a trial judge says, oh, they filled out a not guilty, they did a not guilty, defense attorneys tend to like that. That's good, Judge, they gave a not guilty. But no, defense counsel doesn't have anything to say. And so, this just happens over and over and over again. If this court says, well, we don't want to say it's structural error, okay, is it plain error on assignment of error 2, plain error of assignment error 3, plain error on 4, plain error on 5? 5 isn't even plain error. It's, State versus Green, criminal rule 32A is pretty much mandatory. Even if the trial attorney says, I forbid my client from speaking to you, Judge, well, I'm sorry, I'm required to personally ask the defendant if he has anything to say in allocution, no matter what the trial attorney says. So this just happens over and over and over again. You have a whole issue of plain error, one after another. At what point do you say, we have a Sixth Amendment issue here, even if this court doesn't want to find structural error due to the conflict of interest? I don't know where I am on my
You're
time.
just under 5 minutes total.
No, unless there's any questions, I'll reserve the balance.
Thank you.
Good morning, Your Honor. May it please the Court, Lindsay Paparaki on behalf of the appellate state of Ohio. The state understood that appellant Jeremy Diestler's first claimed error was that he was denied the effective assistance of counsel when the trial court permitted the victim, Matthew Stinson's prior attorney, to represent him at trial despite a conflict of interest. And we would submit that in order to establish a Sixth Amendment violation due to a conflict of interest, a defendant must demonstrate that an actual conflict of interest adversely affected his lawyer's performance. Here, however, because an actual conflict never arose at trial, Diestler was not denied effective assistance of counsel. In order for a defendant to establish an actual conflict, he must first show that some alternative defense strategy or tactic might have been pursued absent that conflict of interest. And he must show that this alternative defense strategy could not have been pursued because of an inherent conflict with the counsel's representation of another client. Here, as appellant's counsel mentioned, the state actually raised the issue of potential conflict with the trial court with respect to Attorney Bradley's prior representation of the victim in this case.
Did the state actually move to have his counsel removed?
They did not. I believe that there was not a motion for disqualification. It was just a motion to have the matter heard on a potential conflict.
But the state obviously was kind of in not the best position for you to try to be arguing now, but whether that means there was or there wasn't. But you're the one that raised the issue and said you're concerned over, the state is the one that raised the issue, so we're concerned over a conflict.
The state did actually raise the issue in the trial court.
But what you're arguing is even though the state was concerned over the conflict, based on what happened at trial, no conflict was actually shown and therefore there's no prejudice.
Correct. I believe appellant's counsel argued that the probate lawyer actually waived a conflict, but what happened was that the court received a waiver from the victim's estate, and the court then reviewed Attorney Bradley's entire file from the victim and found that there was no attorney-client privilege issue and allowed Attorney Bradley to stay on the case. At the hearing on the motion requesting a hearing on conflict, Diestler acknowledged attorney's prior representation of the victim and expressed a waiver on any conflict that might arise. And at the outset, the state notes that Attorney Bradley was Diestler's retained counsel of choice. It seems somewhat incongruent for Diestler to now argue that a conflict of interest existed with Attorney Bradley's representation after an in-depth conversation about a potential conflict occurred with the trial court where Diestler's waiver of such conflict was expressed. As we've noted in our brief, the Ohio Supreme Court has held that prior representation of a victim or a prosecution witness in the past does not in itself constitute a conflict of interest or prejudice. We also noted in our brief that at least 2 appellate courts, the 2nd and the 4th, have held that a defense attorney's subsequent representation of the murder victim, sequential representation of the murder victim and defendant in unrelated cases is not a conflict of interest. This is because the murder victim, who has obviously died prior to the time of the murder trial, has no interest for the defense attorney to protect. This was the case with Attorney Bradley in this matter.
Counsel, do we know if he was retained on the murder victim's case as well?
I believe he was. And here, other than implying that Attorney Bradley did not seem to offer much of a defense and failed to object to numerous irregularities, Diestler has not suggested in this appeal how Attorney Bradley's earlier representation of Stinson affected his trial strategy in this case. Diestler has the burden of showing that Attorney Bradley supplied ineffective assistance of counsel. In this regard, there is a strong presumption that licensed attorneys are competent and that their challenged actions are the product of sound trial strategy. Appellate courts have noted that there is a need to be cautious in reviewing ineffective assistance of counsel claims, as it is too tempting for a defendant to second-guess their trial counsel after a conviction, and it would be all too easy for a court to conclude that a specific act or omission was deficient, especially when examining a matter in hindsight. Here, Diestler second-guesses his trial court's efforts. Given the fact that Diestler retained Attorney Bradley and agreed that he wanted Attorney Bradley as his counsel, even after being informed that there may be a potential conflict, and no actual conflict existed or arose during trial, we would ask that Diestler's first assignment of error be overruled. As noted by appellant's counsel, the next 2 assignments of error relate to the jury's return of the verdict in this case. Diestler contends that the jury's initial return of a not guilty verdict for involuntary manslaughter was inconsistent with its simultaneous return of a guilty verdict on aggravated murder. And he also claims that he suffered error and claims that the trial court spoke to the jury outside of his presence and that of his trial counsel. And the record shows that once the verdict was reached, the jury was led into the courtroom after the trial court acknowledged that everybody was there and that it understood that a verdict had been reached. After the trial court had reviewed the verdict forms, the judge recognized an issue with the verdict forms and told the jurors that they needed to return a verdict on the main offense or the inferior offenses, but not both. Counsel who was present in the courtroom was then asked to approach and provided a more detailed description of what had just been told to the jury. Therefore, the notations in the transcript, which are apparent, and this discussion dispel Diestler's notion that counsel was not present in the courtroom when the trial court engaged in this discussion with the jury. It is clear from the transcript that counsel was present in open court when the trial court engaged in this discussion with the jury. And I believe that there's case law that says that if the transcript has to show otherwise, or there's a presumption that counsel was present. With respect to the jury forms, the state would submit that a verdict is not final for purposes of double jeopardy unless it is accepted by the trial court, and that here the record reflects that the trial court properly re-instructed the jury and expressly refrained from accepting the verdicts until the jury returned from its redeliberations. Because the verdict was initially returned because the verdict as initially returned was fatally flawed and rejected by the trial court, it was not a final verdict, final and valid verdict for purposes of double jeopardy. The trial court had the right to resolve any issues or incongruencies with the verdict and re-instruct the jury to follow its initial jury instructions before accepting the verdict for purposes of finality.
Remind me again, what did the judge actually instruct the jury they had to go back and do?
They had to remove, they only had to make a finding on either the main or inferior offense, not both. When he spoke to them after they returned the verdict,
That's what I'm asking.
yes. And as to the fourth and fifth assignments of error, they related to allied offenses and allocution and plain error, as appellant's counsel discussed. And the state would submit that there was no plain error in the merger of the felonious assault and improper discharge of a firearm offenses, because there were two victims which suffered separate harm. There was a victim that was murdered and another victim that was shot by a stray bullet and obviously suffered separate and distinct injuries. And with the sentencing, Attorney Bradley spoke on behalf of his client and said that he was going to speak on his behalf, and any error in that regard would be either harmless or invited, in that the courts need to address Diestler on his own behalf would have been obviated by the fact that that the court requested Attorney Bradley to speak, and Attorney Bradley indicated that he would do so on Jeremy's behalf. And for these reasons, the state would ask that the court affirm Mr. Diestler's convictions and sentence. Thank you.
Maybe out there, just under 5 minutes.
Thank you, Your Honor. I mean, I think there's an argument that the whole trial was plain error. I mean, I don't know at one point, the trial judge, I think, even asked Mr. Bradley, what's your defense? Well, I haven't put one on yet. Well, what is it? Is it a burden defense? Is it a self-defense? Is it provocation? I'm not sure. No idea what the defense strategy was here, which is why the brief that I filed is plain error, plain error, plain error, plain error. I probably could have multiplied the assignments of error and made everything plain error and ineffective, and plain error and ineffective. We could have had a 9 or 10 assignment of error brief, but I think plain error gets it across, especially with the structural error regarding the conflict. I note that on page 29, and I apologize, I don't know if it's 29 of the trial transcript or if it's a hearing transcript, the prosecutor says Diestlers are saying they believe there's a conflict, but it's unclear if maybe the prosecutor got confused and thought it was the other clients, the decedent's family said there was a conflict, but verbatim in the transcript is Diestlers are saying they believe there's a conflict. That's on page 29. What that means, I don't know. But obviously the trial attorney has, the power here and is speaking for the client. Never should have been handling this case. And regarding the record about whether all this happened in open court, on trial transcript 1400 to 1401, the trial judge says, so I've asked them to go back and remove. They're only supposed to have one, and they have to come back and tell me which one that is. That's on page 1400 and 1401. That past tense discussion suggests that this wasn't done in open court, that the judge had one or possibly two, or plan to have a future ex parte conversation. Ex parte is the right word, but no lawyers were present. If I told this court, I asked the prosecutor where I can get coffee in this building, that obviously didn't happen in open court because you would have heard it. I'm telling you about a conversation that happened before we all convened.
Isn't there any indication in the transcript whether it was an open court and who was there?
I think it's, I think it's pretty vague. I don't think there's anything in the transcript that says, the jury exited or anything like that. Clearly the jury exited because at some point the judge says, okay, everybody's here. Everybody's back. I've asked them to go back. I've asked them to come back. I've asked them to come tell me what they decide to do. this conversation shows that, I mean, the jury didn't sit in the jury box and do the round 2 of their deliberation with everybody sitting there. I mean, the jury must have gone back to the jury room and decided to tear up their not guilty form on the involuntary manslaughter. But the judge is past tense, telling the lawyers, here's what I told the jury. I've asked them to go back out of here, obviously, and remove one of the verdicts. They don't really talk, at no point in the record do they say, uh-oh, they issued a not guilty on the manslaughter and a guilty on the murder. The judge never tells us what was on the murder verdict form. He just says, oh, but we got a big problem, not guilty on the involuntary manslaughter, that's not good. It might suggest that the jury gave a murder, an aggravated murder guilty and an involuntary not guilty, but you won't see that in the record. The trial judge is just, oh my God, we got a not guilty and involuntary, we shouldn't have sent both those forms back. And then there's this whole dialogue of the trial judge telling the lawyers what's going on, which again, if it all happened in open court, why would we be explaining to the lawyers what, I mean, we just witnessed it.
Was it a sidebar? When the trial court had the discussion?
There isn't anything on that suggesting it's a sidebar. It looks like the judge declares in open court, uh-oh, we got a not guilty, and then the jury leaves, and the judge talks to him, and then the judge comes back and says, hey, let me tell you what happened here. At some point the judge says, it's around the 1400 page, says, let me, cut to the chase, or let me, short circuit the surprise. They issued a not guilty, I went back, I told them they gotta change one of them, and then they'll tell me later what they do. Suggesting there's gonna be a second conversation outside the presence of the lawyers. And again, what does Mr. Diestler's attorney say? Nothing. No objection, no concerns. No, Your Honor, I don't think that's appropriate. I think we're getting into, you're damaging my client's rights. No, nothing of the sort. I mean, Diestler really didn't have a lawyer throughout this trial. If there's any questions, I'd be happy to entertain them. If not, I would thank the court for its time.
Thank you. Thank you both for your presentations today. The court will take the matter under advisement and issue a written decision which will be posted to our website, mailed to both sides. Again, thank you for your presentations today.